Chairwoman, thank you very much, and thanks to our panelists. A very important hearing. Thank you for holding it. Passage of federal data privacy legislation is long overdue. I chaired the subcommittee on data privacy that Senator Hickenlooper now chairs, and Senator Blackburn is the ranking member. Senator Blumenthal was the ranking member. We have come so close so many times, but never just quite across the finish line, and the problems and challenges with our lack of success continue to mount. And it gets, I don't know that the issues get more difficult to resolve, but we still haven't found the will to overcome kind of the differences of the things that each of us think is pretty important. I reintroduced my comprehensive data privacy, Consumer Data Privacy and Security Act, again in this Congress. Gives Americans control over their own data, establishes a single clear federal standard for data privacy, and provides for robust enforcement of data privacy protections that does not lead to frivolous legal actions that would harm small business. I think these are common sense policies, and again, I think there's a path forward utilizing those, and I would again say in this hearing, as I've said numerous times over the years, I'm willing to work with any and all to try to find that path forward. I have a few questions for the panel. I think I start with you, Mr. Reed. Important that data privacy requirements, in my view, established by federal law are shared by consumer-facing entities, service providers, and third parties, all of which may collect or process consumer data. Exempting segments of this value chain from requirements or enforcement under the data privacy law, I think, places an unfair burden on consumer-facing entities, including particularly small business. Mr. Reed, is that something you agree with? When it comes to data privacy, regulatory burden should be shared across each entity that collects or processes data?
I do, but I want to be careful about one thing. I don't want to, I know this sounds weird coming from the business side, so to speak, but I want to be careful that we don't say that shared responsibility becomes everybody touching their nose and saying, I'm not it. So I think the point at which you give your data over, the point at which you have that first contact, whether it's my members through an application or through a store that you visit, is the most logical point for the consumer to begin to say, hey, I want my data to be retrieved, or I don't want my data used in this way. So I think, yes, there is shared responsibility across the chain, but I don't want a situation where the front person who interacts with the customer can then say, hey, that's down the food chain, 3 third parties from there.
And
so I think that's important.
You avoid that by?
Well, you avoid that by actually having a clear and concrete conversation, so to speak, with the customer when they provide the data. Here's what you're getting in exchange, here's what the rules of the road are, and that's why a federal comprehensive privacy bill, and we appreciate the bill that you've worked on already on data, moves us in a direction of having consumers nationally have an understanding of what their rights and what our responsibilities are with their data. So absolutely, but it has to start with an understanding at the first place and then the shared responsibility throughout the chain.
One more for you, Mr. Reed. 19 states, I think, is the number that have passed their own data privacy laws. It's a patchwork of state data privacy laws increasing compliance costs. One estimate projects a compliance cost for business could reach $239 billion annually if Congress does not implement its a data privacy law. Incidentally, I came to Congress believing and still believe that government closest to home is better than government far away, but it seems like I spend a bunch of my time trying to figure out how we take care of a complex situation with 50 different states and 50 different standards. Kansas doesn't have a data privacy law, but borders 2 states that do.
Exactly.
Would you describe the challenges for small business associated with working in states with different data privacy standards?
Well, your state is one of the ones in particular that we find most interesting, because you literally have businesses in your state that have a primary number of their customers are actually from the bordering state, because you have that crossroads that exist. So for Kansas and Oklahoma, you have customers across the border literally every day. So having a mixture of these privacy bills, now to be clear, a lot of states have some sort of small business carve out, but it's different and the definitions are different in every state. So any business that participates is going to have to figure out who's going to tell them what they do, and if that customer walks in and says, my zip code is this, oh, sorry, I have to treat your data this way. If it's this, then I have to do it another way. It is soul-crushing for a small business to have to interview each purchaser and ask them what county they live in or what state they live in. So it's a huge burden on small business, and unfortunately it's one that's really a lot easier for a multinational company to handle.
Let me quickly ask Mr. Tawari and Ms. Koch. CAC, it's important for Americans to understand when their data is collected and processed by companies. This belief is reflected in our data privacy legislation, which requires covered entities to publish their privacy policies in easy-to-understand language and to provide easy-to-use means to exercise their right to control over data. How can a federal policy ensure consumers are aware of their data is being used, even as AI potentially increases the complexity of how consumer data is processed?
Thank you, Senator. It is essential for us to recognize that purely relying on consent has proven to be ineffective to protect the privacy of the average consumer. Technology has now become such a complex endeavor that to expect an average consumer to understand everything that can happen when their data is collected is a burden that they will never be able to meaningfully fulfill. And therefore, any effective federal privacy legislation must include accountability measures that also place obligations upon these entities for what they cannot do, regardless of whether the consumer has consented to that behavior or not. Only then can consumers be sure that the government is working effectively to protect their privacy rather than hoping that they understand everything that may happen to their data.
It's a sad state of affairs, actually. We can't understand it well enough to protect ourselves. Anything to add?
Yeah, the only thing I would add, Senator, is sort of what do we do as consumers with that information? And that's really why transparency isn't enough and why proposals like the bipartisan ADPPA and the APRA are so important, because they're putting down sort of rules of the road that apply regardless of consent and what consumers choose.
Thank you both.